This is John Rutan, the grumpy old vet. If you are committed to restoring the Constitution and keeping your republic, I urge each of you to forward this video to your local sheriff. Restoring the Constitution. Why every sheriff must know the Constitution. 1. Introduction. Restoring the Constitution. Why every sheriff must know the Constitution. Good morning. I want to take a few minutes to talk about something that is not only foundational to law enforcement, but essential to liberty: the importance of a sheriff's knowledge of the federal Constitution. Let's start with a simple truth. The sheriff is not just another law enforcement officer. They are the chief law enforcement officer in the county, elected by the people, not appointed by politicians. That makes the sheriff uniquely accountable to the citizens, not to the governor, not to a judge, and not to the federal government. This office is older than the country itself, dating back to English common law and adopted directly into the American model of government. That heritage comes with a sacred duty: to uphold and defend the Constitution of the United States against all enemies, foreign and domestic. But let's be honest, how can any sheriff swear an oath to the Constitution if they don't understand what it says, what it means, and what it forbids? The Constitution is not just a suggestion, it is the supreme law of the land, per Article 6. Every law, every statute, every directive, every executive order must comply with it. The sheriff is often the last line of defense when those in power overstep their bounds. And I don't mean that abstractly. I mean boots on the ground, real-world defense of constitutional rights when federal agencies, state bureaucrats, or even judges attempt to trample on the people's liberty. Let me give you a concrete example. Suppose a federal agency comes into your county to confiscate firearms under a red flag law, without due process, without a warrant issued upon probable cause, and without the individual having committed any crime. Is it legal just because a law was passed somewhere? Absolutely not. That is a direct violation of the Second, Fourth, and the Fifth Amendments. A sheriff who understands the Constitution can and must intervene, not as an outlaw, but as a constitutional officer standing between unlawful government action and the people. Too often today, law enforcement is trained to follow policy, procedure, or case law without ever asking the foundational question: is this constitutional? That question isn't just academic, it's a moral and legal obligation. The Constitution sets the boundaries for all government action, including law enforcement, and the sheriff, as the only elected law enforcement officer in the county, has a unique duty to ensure those boundaries are respected. That duty extends to every amendment in the Bill of Rights. The First Amendment protects the right of free speech, religious exercise, and assembly. In times of crisis, COVID lockdowns, for instance, many sheriffs across the country had to decide whether to enforce orders closing churches, shutting down businesses, or banning peaceful protest. The constitutionally informed sheriff knew those rights are not suspended in emergencies. In fact, that's exactly when they matter most. The Fourth Amendment guards against unreasonable searches and seizures. Every warrantless raid, every asset forfeiture, every overbroad surveillance operation must be evaluated through the lens of the Constitution. A sheriff who understands that won't just go along with unconstitutional seizures because some agency says it's okay. He'll stand his ground. The 10th Amendment is especially important. It says that powers not delegated to the federal government are reserved to the states and the people. This is the backbone of federalism, the idea that the federal government is limited in scope, and the states retain sovereignty. The sheriff is a guardian of that sovereignty. If the federal government begins acting outside its authority, whether it's unconstitutional regulations, mandates, or enforcement actions, it is the sheriff's duty to protect the rights of the people and push back. Let me remind you what James Madison, the father of the Constitution, said in Federalist Paper 46: the local governments, including the militia and the people, are the surest check on federal overreach. The modern-day sheriff is the constitutional descendant of that local check on centralized power. We live in an era where the federal bureaucracy has grown larger than the founders could have imagined. Agencies like the IRS, ATF, FBI, and others operate with immense power and little accountability. That's not fear-mongering, that's just the truth. In that kind of environment, who will protect the farmer, the business owner, the gun owner, or the churchgoer from being steamrolled by federal policies that are unconstitutional, unjust, or simply tyrannical? The sheriff can, and the sheriff must. Now, this doesn't mean the sheriff is at war with the federal government. It means the sheriff is a constitutional buffer, upholding his oath, preserving peace, and ensuring that every citizen's God-given rights are protected even from the government itself. But that responsibility only matters if the sheriff actually knows the Constitution. Reading the document, studying the founder's intent, understanding court precedent, these are not optional for someone with this much authority. They're essential. And I'll go further. The sheriff should be a teacher of the Constitution, not just a guardian. Deputies should be trained in constitutional policing. Schools should be encouraged to teach the actual text of the Constitution, not just interpretations. And the public should know that the sheriff stands with them when their rights are under threat. We do not live in a democracy. We live in a constitutional or compound republic. That means we don't just follow majority rule. We follow the rule of law, and the highest law is the Constitution. If a sheriff forgets that, or worse, never learns it, he becomes just another bureaucrat enforcing whatever he's told. But a sheriff who knows the Constitution becomes something much greater, a true defender of liberty. I'll say this: the badge of a sheriff is not just a symbol of authority. It's a symbol of service, of accountability, and of constitutional duty. That duty doesn't stop at the jailhouse door or the courthouse steps. It runs all the way to the Bill of Rights and back to the people who elected him. So to any sheriff listening, learn the Constitution, live it, teach it, and defend it. Because if you won't, who will? Deep constitutional training available. For anyone seeking a thorough and well-informed introduction to the Constitution, I strongly encourage you to watch my 28-week class available on both YouTube and Rumble. On YouTube, visit the channel Hillsdale Liberty Hall, and on Rumble, the channel is JPR64. This course begins with a deep dive into the ancient historical foundations necessary to truly understand Americanism and our unique form of government. We start in 1042 England, under King Edward, exploring the roots of the common law, the source from which nearly all our modern legal doctrines flow. From there, the course takes you through a full reading, in their original text, of the 5 genealogical documents that directly shaped the American legal tradition and much of the federal Constitution as we know it today. These foundational documents include 1. The 1100 Charter of Liberties, signed by King Henry I. 2. The Magna Carta of 1215, authored by Bishop Stephen Langton and signed by King John. 3. The Petition of Right of 1628, issued by Parliament to King Charles I. 4. The Grand Remonstrance of 1641, written by the House of Commons and also addressed to King Charles I 8 years before his execution. 5. The British Bill of Rights of 1689, enacted by Parliament and signed by King William and Queen Mary. These documents are crucial to understanding our heritage. As Patrick Henry once said, "I have but one lamp by which my feet are guided, and that is the lamp of experience. I know no way of judging the future but by the past." The more clearly we understand the past, the better equipped we are to make sense of the present and anticipate what lies ahead. From there, the class moves into the American founding. We study the Declaration of Independence, which stands as the first formal founding document of the United States, built on the principles first outlined in the British Bill of Rights. The Declaration not only asserts our right to self-governance, it codifies the foundational ideas that would later be enshrined in the federal Constitution. We explore in detail the history of the American colonies from 1750 to 1776, uncovering the true causes of what began as a civil war and became the Revolutionary War following the Lee Resolution on July 2, 1776. You'll also examine Patrick Henry's legendary speech, "Give me liberty or give me death," and Thomas Paine's American Crisis, published just 24 hours before Washington crossed the Delaware in the bold attack at Trenton. We also highlight Benjamin Franklin's powerful speech at the 1787 Constitutional Convention, where he addressed the issue of executive salaries. His insights in that speech are timeless and offer tremendous wisdom relevant to modern political life. The class then undertakes a full study of the Declaration of Independence, which Abraham Lincoln famously referred to as the frame of silver that surrounds the apple of gold, the Constitution. We examine the 27 specific grievances listed in the Declaration, many of which reflect violations of British constitutional law, particularly the very laws King George III had sworn to uphold. We then dig into the Federalist Papers, focusing on 8 key essays, numbers 1, 10, 24, 39, 41, 45, 49, and 51, to understand the founders' arguments for the structure and powers of the new government. This includes a detailed analysis of James Madison's speech before the Second Congress, known as the Cod Fisheries Debate, where Madison reaffirms constitutional principles he had already laid out in the Federalist Papers. From there, the course provides an exhaustive study of the entire Constitution, including all 7 articles, every section, and every clause. We also examine the Bill of Rights, along with every later amendment. Finally, the series concludes with a 6-part video study on what happened to the Constitution during the 20th century, how its principles were eroded or reinterpreted, and how those changes have shaped where we are today at the dawn of the 21st century. Whether you're new to the Constitution or looking to deepen your understanding, this 28-week course offers the most comprehensive and historically grounded education you'll find online. I invite you to join me, and let's reclaim the knowledge and principles that built the greatest constitutional republic in the history of the world. This course is especially important for sheriffs, as it reveals key constitutional principles essential to their role. In particular, the Magna Carta of 1215, specifically subsection 61, marks a critical turning point in the evolution of the sheriff's authority. There, the sheriff transitions from being merely an agent of the crown or state, serving the interests of centralized power, to becoming a guardian of the people, empowered with state authority but answerable directly to the people, acting as a firewall against potential abuses of state power. Further, Federalist Paper 39 outlines the division of sovereignty between national and state governments and helps define the local jurisdictional authority of county sheriffs. Madison explains the federal nature of our republic, which means that the local sheriff, duly elected by the people, holds final authority in matters within the county. This framework supports the principle that sheriffs have constitutional jurisdiction over both state and federal entities when operating inside their counties. By studying these foundational texts and principles, sheriffs will be equipped with the historical, legal, and philosophical grounding necessary to uphold their oath, not merely as law enforcers, but as constitutional officers duty-bound to protect the rights of the people and to serve as a bulwark against tyranny, whether it comes from Washington or the state capitol. 2. Foundations of the Constitution. Now, we're going to talk about what it truly means to take an oath to support and defend the Constitution of the United States, especially for those who serve in positions of trust like the sheriff. To do that, we'll explore the foundational ideas of natural rights, the structure of our constitutional government, and how the sheriff's office fits into the federal framework that was designed to protect liberty, not government power. A. Natural rights and the Declaration of Independence. Our story begins not in 1776, but centuries earlier, with philosophers like John Locke and Montesquieu, who articulated the idea of natural law. Natural law teaches that our rights do not come from kings, parliaments, or bureaucrats. They come from God, or from nature and nature's God, as Thomas Jefferson wrote in the Declaration of Independence. Locke argued that all people are born with certain inalienable rights: life, liberty, and property. and that the only legitimate purpose of government is to secure these rights, not to invent or restrict them. Jefferson echoed this principle when he wrote, "All men are created equal, not that we all have equal talent or outcomes, but that we all have equal moral worth before the law." In other words, there is no divine right of kings, and no man has any natural authority over another except what is consensually given. From this principle flows the powerful assertion that governments derive their just powers from the consent of the governed. That consent is given through elections, constitutions, and ultimately through the ongoing vigilance of the people, and crucially, through constitutional officers like sheriffs, who are elected directly by the people to guard their rights. B. Federalism and separation of powers. Now, how did the founders take these philosophical ideas and make them into a working government? They did it through two major structural innovations: federalism and separation of powers. Federalism is a system of dual sovereignty, meaning that power is divided between two distinct levels of government, the states and the federal government. Both derive their authority from the people, and both are accountable to the people. In Federalist 39, James Madison explains that the new Constitution is partly federal and partly national. It is federal in the sense that the states retain a sphere of sovereignty and elect their own officers, like sheriffs. And it is national in the sense that certain powers, like declaring war or regulating foreign commerce, are exercised by the central government. But the founders didn't stop there. They also built into the Constitution a system of horizontal separation of powers through Articles 1, 2, and 3, which divide authority among the legislative, executive, and judicial branches. Each branch was given limited, enumerated powers, and each was given tools to check the others. As Madison wrote in Federalist 51, ambition must be made to counteract ambition. In other words, the Constitution assumes people in power will seek more power, and it deliberately sets them against each other to prevent any one branch from becoming supreme. That's why Congress passes laws, but cannot enforce them. The executive enforces the law, but cannot make it. The judiciary interprets the law, but cannot write or execute it. And this principle of divided power applies vertically as well. States are not subdivisions of Washington, D.C. They are sovereign governments, with their own constitutions and their own officers, including sheriffs. See, a republic, not a democracy. It's also important to correct a widespread misunderstanding. The United States was never intended to be a pure democracy. It was designed to be a constitutional republic. A democracy, pure and unrestrained, is just majority rule. 51% of the people can vote away the rights of the other 49. That's mob rule. And history shows that democracies without checks quickly descend into tyranny. Our founders knew this. That's why they created a republic, a government bound by law, with power dispersed across institutions, and with specific checks in place to protect minority rights, due process, and the rule of law. Consider these examples. The Electoral College ensures that small states have a voice in presidential elections. The Senate gives each state equal representation, regardless of population. The Bill of Rights puts fundamental liberties beyond the reach of any simple majority vote. This is where the office of the sheriff plays a uniquely critical role. The sheriff, as the chief law enforcement officer in the county, is not a bureaucrat appointed by the state. He is elected directly by the people, and his job is not simply to enforce laws, but to protect the constitutional rights of all people, especially those under threat by popular opinion or state overreach. When an unpopular person's rights are trampled, due process denied, property seized, voice silenced, it is the sheriff's duty to stand in the gap, regardless of pressure from above or from the crowd. D. The sheriff, a constitutional officer. This leads us to a vital historical point. In the Magna Carta, 1215, particularly subsection 61, the role of the sheriff began to evolve. The sheriff had been an agent of the king, acting in the interest of the crown. But subsection 61 laid the foundation for accountability to the people, that the sheriff must protect them from the king, if necessary. Our American tradition took this further. The sheriff became an independent constitutional officer, with state authority, yes, but deriving his legitimacy directly from the people of the county, not from the governor, not from the president, and not from any federal agency. In this way, the sheriff becomes a firewall against both federal and state tyranny, a protector of liberty on the front lines of constitutional governance. James Madison in Federalist 39 makes it clear the sovereignty of the people is expressed not just in the federal government, but in the states and local governments, where elected officials like the sheriff are most accessible and accountable to the people. The sheriff's authority is not subordinate to federal or state bureaucrats. Within their county, sheriffs have the duty and the authority to interpose if necessary to defend constitutional rights against unlawful orders or intrusions, be they federal, state, or local. Conclusion: the oath and its meaning. So when a sheriff raises his hand and swears to support and defend the Constitution, he is not merely reciting a formality. He is swearing to uphold a framework that recognizes that rights come from God, not government. That power must be restrained and divided. That minority rights must be protected, even against the passions of the majority. And that local officials, like the sheriff, are critical defenders of liberty at the ground level. This constitutional vision is not a theory, it is a duty. And as Americans, it is our job to understand it, live it, and hold our elected officials, especially our sheriffs, accountable to it. Because in the end, liberty does not defend itself. It requires knowledge, courage, and action. And there is no office better positioned to do that than the constitutional sheriff. 3. The role of sheriffs in upholding the Constitution. Now, I want to talk to you about something fundamental, not just to our law enforcement structure, but to our very system of government. It's the role of sheriffs in upholding, defending, and preserving the Constitution of the United States. We live in a time when many in government, at all levels, have either forgotten or rejected the limits placed on them by the Constitution. In such times, the role of local elected constitutional officers becomes absolutely vital. The sheriff is not just a law enforcer. The sheriff is a guardian, a protector of individual rights, a check against unlawful government overreach, and a direct line of accountability to we the people. Let's begin where it all started. History. A historical context. The sheriff as a constitutional defender. The office of sheriff has its origins in Anglo-Saxon England, where the shire reeve was appointed by the king to maintain peace and collect taxes. But over time, the position evolved. By the time of the Magna Carta in 1215, sheriffs were being restrained by law, not empowered above it. Subsection 61 of the Magna Carta even established a system where local barons, and by extension, local officers, could resist the king himself if he violated the people's rights. That idea, that local authority could be a check on central tyranny, was carried forward by our founders. By the time of the American colonies, sheriffs had become elected officials in many states. Unlike federal agents or state police, the sheriff answers only to the people of the county, not to a governor, not to a legislature, and not to a president. The founders expected local officials like sheriffs to resist unconstitutional orders. They built a system of federalism and local autonomy, expecting that power would be pushed downward, not hoarded at the top. In Federalist 39, James Madison wrote that our system is federal in nature, not merely national, meaning states and their subdivisions retain real sovereignty. He also wrote that the sources of power must remain close to the people. That is exactly what the office of sheriff represents. Power held closest to the people by someone they can elect or remove. So the office of sheriff is not just a holdover from history, it's a pillar of the American constitutional system. B. Modern responsibilities, the sheriff in the 21st century. In the modern age, sheriffs are facing new challenges, but the principles remain the same. Sheriffs must understand the limits of federal and state power. Just because a governor signs an executive order doesn't make it lawful. Just because a federal agency issues a mandate doesn't mean it's constitutional. Take, for example, COVID-19 lockdown orders, which shuttered churches, small businesses, and schools, often without legislative approval. Red flag laws, which allow firearms to be seized without due process or trial. Civil asset forfeiture, where property is taken without a conviction or sometimes even a charge. In each of these scenarios, the question is not simply, is this legal, but is this constitutional? Conclusion: the sheriff's duty. The sheriff has both the authority and the responsibility to say no to unconstitutional mandates, and history honors those who have. Whether it's sheriffs who refuse to shut down churches during COVID, or those who refuse to enforce gun confiscation laws, these men and women are doing their duty. It's also important to emphasize the discretionary power of the sheriff. Law enforcement is not supposed to be robotic or mechanical. It requires judgment. It requires a clear understanding of the spirit of the law, not just the letter. The sheriff is often the last line of defense between the people and an overreaching government. That's not an exaggeration. It's a constitutional reality. 4. Key constitutional amendments relevant to law enforcement. Let's now turn to the specific constitutional provisions that every sheriff must know and uphold. If we're going to protect liberty, we must know where it's written and what it means. A. Second Amendment. The Second Amendment states plainly, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This is not about hunting or sporting. It's about self-defense, not only from criminals, but from tyranny. Historically, the militia was made up of the people themselves, armed and organized to defend their communities, not under federal control, but under local authority, often under the county sheriff. James Madison, in both the Bill of Rights and the Federalist Papers, warned about the danger of a standing army controlled by a centralized government. The militia, he said, was the counterbalance, locally armed, locally controlled. So when the federal government tries to infringe on the right to bear arms, whether through registration, red flag laws, or executive orders, it is the sheriff's duty to interpose, to say, not in my county. Sheriffs must defend the right of law-abiding citizens to own, carry, and defend themselves with firearms. This is not optional. It is a matter of constitutional oath. B. Fourth Amendment. The Fourth Amendment reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. This is the foundation of privacy rights. It requires that searches and arrests be based on probable cause and supported by a warrant issued by a judge. This amendment is crucial in an age of surveillance, federal raids, and digital intrusion. It is your responsibility as sheriffs to ensure that every search, every seizure, every arrest meets constitutional standards. That means your deputies must be trained, not just in tactics, but in constitutional law. It also means you must be ready to stand up to other agencies, yes, even federal ones, if they violate these principles in your county. The people you serve are not subjects. They are free and independent citizens, entitled to due process. See Fifth and Sixth Amendments. Let's turn to the Fifth and Sixth Amendments. These are often misunderstood, but they are absolutely vital to law enforcement. The Fifth Amendment guarantees due process of law protection against self-incrimination, protection against double jeopardy, just compensation for eminent domain. The Sixth Amendment guarantees a speedy and public trial, an impartial jury, the right to be informed of charges, the right to confront witnesses, the right to legal counsel. Let's be clear, these rights are not just for the innocent, they are especially important for the accused. Our system is built on the principle that a person is innocent until proven guilty. That is not just a legal formality, It's a moral imperative. As sheriffs, you are first contact with the criminal justice system. That means you are also the first guardians of these rights. If an arrestee isn't read their rights, if they are denied access to a lawyer, if they're held without cause or coerced into confessing, that's not justice. That's tyranny. Your duty is not only to enforce the law, but to ensure that the law is applied fairly, consistently, and constitutionally. Conclusion: the sheriff's oath and legacy. When you took the oath of office, you didn't swear allegiance to a party, a person, or even a policy. You swore allegiance to the Constitution of the United States and to the Constitution of your state. That oath is your shield and your sword. It is your duty and your protection. It is your contract with the people who elected you. In Federalist 51, Madison reminds us that government is necessary, but so is limiting government. Ambition must be made to counteract ambition. The sheriff's office is one of the counterweights. You are the buffer between the citizen and the state. In every generation, liberty faces new threats. But our Constitution remains, and it requires people of courage to uphold it. Be one of those people. Stand your ground. Know the Constitution. And be the sheriff the founders envisioned, a guardian of the Republic, a defender of the people, and a servant of the law, not of power. 5. Contemporary challenges and the Constitution. In this segment, we're going to look at the contemporary challenges that are testing the boundaries of the Constitution, the limits of federal power, and the responsibilities sheriffs must shoulder in this modern climate. Let's begin with something that affects us all, whether we realize it or not: federal overreach. A. Federal overreach, what it looks like. Today, there are numerous examples where the federal government has extended its reach far beyond what the founders ever intended. We see this in the actions of federal agencies like the ATF, the DEA, and the Department of Homeland Security. Let's take the ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Time and again, this agency has issued rules that amount to lawmaking. Whether it's redefining pistol braces or arbitrarily changing firearm classifications, the ATF continues to trample on the rights of lawful gun owners without congressional authorization. That is legislation by bureaucracy, plain and simple, and it's unconstitutional. Now consider the DEA, the Drug Enforcement Administration. In many states, perhaps yours, marijuana has been legalized in some form. Yet the DEA still operates under federal law that classifies marijuana as a Schedule I drug. That means sheriffs may find themselves caught in the middle, pressured to cooperate with federal agents while their own state has declared such actions to be legal. It raises an important question: whose law should the sheriff uphold? Then we have the Department of Homeland Security, a massive post-9/11 bureaucracy that now surveils not only foreign threats, but increasingly, everyday Americans. Whether it's through fusion centers, mass data collection, or threats to label dissenting voices as domestic extremists, DHS has become emblematic of federal intrusion into our civil liberties. These examples all point to the same constitutional crisis: the erosion of local authority and the expansion of federal control. Now, let's anchor this in the Constitution itself, specifically the 10th Amendment. It states, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." This is not a throwaway line. The 10th Amendment is a direct expression of federalism, a division of power designed to prevent tyranny. And it tells us something essential: if a power wasn't given to the federal government, it doesn't have it. Period. As sheriffs, we are uniquely positioned to act as a constitutional buffer between the people and illegitimate authority. That leads us to two very old and very powerful ideas: nullification and interposition. B. Nullification and interposition, constitutional resistance. Now, these aren't radical concepts. In fact, they were championed by two of the most foundational voices of our republic, Thomas Jefferson and James Madison. In the Kentucky and Virginia resolutions of 1798, Jefferson and Madison argued that when the federal government enacts laws beyond its constitutional limits, it is up to the states, and, by extension, local officials, to interpose themselves between the people and tyranny. Jefferson wrote, and I quote, "Where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy." And Madison, often called the father of the Constitution, warned us in Federalist 46 that when the federal government becomes oppressive, it is up to state and local governments to resist through refusal to cooperate with officers of the Union. Let me be clear, nullification is not rebellion. It's not about violence or lawlessness. It's about obeying the highest law, the Constitution, even when that means refusing to enforce lesser, unlawful decrees. That is the tradition that informed our founding, and that is the duty of every sheriff today. C. State sovereignty, reclaiming our republic. This brings us to state sovereignty, a concept that has almost become taboo in modern politics, but is absolutely essential to understanding our republic. States are not subsidiaries of the federal government. They are not branch offices of Washington, D.C. In the constitutional order, they are sovereign political entities with their own powers, their own constitutions, and their own duty to protect their people. And sheriffs, as elected county officials, are part of that sovereignty. They are not federal agents. They are not under the command of the governor. Their first and highest loyalty is to the Constitution and to the people who elected them. That's why it is absolutely proper and necessary for sheriffs to resist unconstitutional state or federal actions. Let me give you a few examples. This includes local responses to immigration enforcement. While the federal government may not commandeer local authorities to enforce immigration law, immigration falls under Article 1, Section 8, and its enforcement is the duty of the executive branch under Article 2. When local law enforcement receives a lawful 48-hour ICE detainer, sheriffs are constitutionally justified in holding the individual for up to 48 hours to allow ICE to assume custody. If ICE fails to take custody within that time, the individual must be released to protect due process rights. When governors or health departments attempt to enforce vaccine mandates, they are facially unconstitutional and in violation of individual rights. Sheriffs must protect the people's bodily autonomy. When agencies try to seize private property without due process, whether through civil asset forfeiture or EPA land grabs, it is the sheriff who must step in and uphold the Fourth and Fifth Amendments. Now you might hear, but those are federal laws and sheriffs must comply. Not so fast. If a law is unconstitutional, it is no law at all. That's not my opinion. That's Supreme Court precedent, as stated in Marbury v. Madison in 1803. A law repugnant to the Constitution is void. This means the sheriff is not only within his authority to refuse enforcement, he is bound by his oath to do so. So where does this leave us? It leaves us in a place of great responsibility and great opportunity. Yes, the Constitution is under assault, from without and within. Yes, federal agencies often act like unaccountable empires. Yes, even state governments sometimes become complicit in violating our rights. But the genius of our system, the beauty of federalism, is that it doesn't all rise or fall on Washington. The sheriff, the elected guardian of the county, is the constitutional firewall. He has the power and the duty to say, "Not in my county, not without a warrant, not without due process, not without respecting the Constitution I swore to defend." Conclusion: a time for courage. In these modern times, when so many are eager to surrender liberty for the illusion of safety, the sheriff must stand firm. We must reclaim the courage of Jefferson, the wisdom of Madison, and the resolve of our founders. In the words of Benjamin Franklin, they who can give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. Sheriffs must not trade away the rights of their people for political expediency or federal funding. Because ultimately, liberty doesn't live in D.C. It lives in the hearts of free people. And it is defended by sheriffs who remember who they serve and why they were elected. 6. Action steps for sheriffs. As the chief law enforcement officer in your county, the sheriff holds a unique and sacred duty to defend the Constitution and protect the God-given rights of the people. Upholding that duty in today's complex political and legal landscape requires more than just courage. It requires action, education, and engagement. Let's explore some practical steps that sheriffs across the country can take to reaffirm their oath and fulfill their constitutional responsibilities. A. Education, the foundation of constitutional integrity. The first and most vital action step is a personal commitment to study. The Constitution is not a one-time read. It is a document that demands ongoing engagement. Sheriffs must take ownership of their understanding of the founding documents, not just the Constitution, but also the Declaration of Independence, the Bill of Rights, the Federalist Papers, and the philosophical works that informed them, such as Locke's two treatises of government and Montesquieu's The Spirit of the Laws. These are not relics of the past. They are roadmaps for modern governance. As a sheriff, you should also encourage your deputies and staff to undergo constitutional training. This can include seminars, reading groups, or hosting constitutional scholars to speak at department events. Knowledge empowers enforcement with wisdom and restraint. But this education cannot remain internal. Sheriffs are uniquely positioned to be community educators. Host town halls and public events to teach the Constitution to your citizens. Partner with schools, churches, and civic organizations to bring constitutional education back to the people. When the community understands their rights, they become better equipped to stand with you in defense of them. B. Community engagement, building trust and resistance to tyranny. Second, sheriffs must actively engage with their communities. This goes beyond standard public relations. You must work with the people to identify unlawful or unconstitutional mandates, whether they come from the state capitol or from Washington, D.C. Federal or state orders that infringe upon natural rights must be openly and constitutionally scrutinized. Build trust with your community by enforcing the law with restraint and respect for individual rights. Be transparent about your priorities and your constitutional commitments. When people see their sheriff respecting due process, upholding the Bill of Rights, and listening to their concerns, they are more likely to view you not just as an enforcer, but as a protector. Consider forming a civilian advisory group comprised of pastors, educators, veterans, and constitutionalists to advise your office on matters of constitutional compliance. This keeps you connected to the moral pulse of your county and ensures you are not isolated in the exercise of your authority. C. Policy implementation, putting the Constitution first. Finally, take proactive steps to embed constitutional fidelity into the operations and policies of your department. Begin by formally adopting department-wide policies that prioritize constitutional protections. For example, explicitly ban warrantless surveillance or asset forfeiture without due process. Place strict protocols around use of force, arrests, and detentions, always aligning with the Fourth, Fifth, and Sixth Amendments. Establish a constitutional compliance review board within your department. This internal team could regularly review proposed policies, legislation, or executive orders to assess their compatibility with the Constitution. Much like a legal audit, this step will safeguard your department from becoming an unthinking arm of bureaucratic overreach. Most importantly, refuse to enforce laws, orders, or mandates that violate constitutional rights. Whether it's a federal firearms registry, a state mandate restricting worship, or an executive order that violates the rights to speech, assembly, or privacy, the sheriff has both the duty and the authority to interpose on behalf of the people. Remember, your oath was not to a governor or a federal agency. It was to the Constitution of the United States and of your state. Conclusion: Guardians of Liberty. When sheriffs commit to education, engagement, and principled policy, They breathe life back into constitutional government from the bottom up. These steps are not about politics. They are about preserving liberty. As Benjamin Franklin famously said, a republic, if you can keep it. Sheriffs are among the few officials with both the authority and proximity to the people to ensure that we do, in fact, keep it. The road ahead requires resolve, wisdom, and humility. But if sheriffs take these action steps seriously, they will become not just law enforcers, but guardians of liberty for generations to come. 7. Questions and answers. Thank you for attention and interest in this presentation. Are there any questions I can answer about this presentation?